So folks, let me say a pleasant good morning, good evening, good afternoon, based on the location. My name is Emmanuel Thomas. This is DTV Online. We yet again on day 2 upon the capital building Arson case, where we get views of the defendants. So the defendants are already so we are waiting the three lawmakers, and they say House Speaker Abu Kamara, the former House Speaker, Fonati Koffa, Debee, and the others to go on with chit-chat conversations to better give a clear analysis on the hearing. Last week we were here again to bring you the things happened today again we here. So whatever you are following, keep sharing. We are with this lawmakers to come together a clear understanding pertaining to the entire process. So stay tuned. Don't go away.
So defendants will be leaving the court as trial ends for today.
So we have seen series of lawyers who sat on the just ended ruling. We have seen series of lawyers who sat on the just ended ruling. So we hope to talk to the lawmakers who were present. Okay. So now we see Fonati Koffa, former House Speaker. Let me zoom in my camera. See.
So here
Here we bring you former House Speaker Fonati Koffa along his lawyer, Councillor Arthur Johnson. Honorable House Speaker, good afternoon.
You are here today against the Liberia What your different things are going to arguing to ensure that you are free from this?
Okay, so, I think last December we were all treated to the term ultra-virus. The term you're going to take today is called fruit tree. It means that when you gather evidence illegally, you can never use that evidence in a trial. And what we saw today was phones were broken into by the police on December 19th, sent to NSA, and then a warrant was gotten on January 9, 2025. It means that's the fruit of the poisonous tree. It means all that evidence. The fruit of the poisonous tree comes from the Garden of Eden, right? Also, you can eat everything here except for this fruit. That fruit that was eaten by the police cannot be used. That snake baby, it must be crushed.
So the former House Speaker spoke in private tone. So the former House Speaker spoke in private. So we will talk. Go back to Abu Kamara. So I think you listen to
the current
the law in our jurisdiction is clear. The criminal procedure law. You are not forced to file the magisterial Also filed a motion to suppress the evidence in the court that has trial jurisdiction. And so the court that has the trial jurisdiction is Criminal Code A. And the key questions that we raised regarding the case is that...
Because Johnson, the issue here is that...
You actually, you're not waiting for me to submit.
Your defense team filed similar motions as before the magistrate.
That's why I'm trying to give you the information. This court is a proper court because it's the court that has trial authority. And you always find out when there is an indictment that is being served on the party. So after the indictment, there's something we call discovery. The discovery is where you ask the court to compare the prosecution under the doctrine of notice to turn over all the evidence that the government has against the client. So when they do that, they turn the evidence over to you. You look at the evidence, analyze the evidence, and if you have any reason to question the evidence, that is the stage. So that is the trial procedure. Now, so you will ask, what did we say and what did we really ask for today before the court? The evidence that the prosecution turned over to us speak that the extraction of the evidence from the defendants, meaning the cell phones information that they took from the defendants, that they said they used to have evidence against the defendants, they extracted those evidence without a search warrant. On December 20th, when they turned over the case to the National Security Agency, the NSA, NSA was the one that conducted the forensic analysis of the evidence on December 20, 2024. And then, looking at these defects, they knew that these were procedural defects that would be questioned at the level of the trial. So on January 9, 2025, after 1 month, then they went and asked for a search and seizure. To what? To say that the evidence were collected on January 9, when in fact they have already collected the evidence and seized the evidence on December 20th. So when you do that illegally, because without a search warrant, without an application to the court requesting for the search warrant, then the evidence is faulty. So when you hear we were saying that the evidence is faulty, and that all of the other evidence that came as a result of that illegal conduct carried out by the NSA and the police must be suppressed, meaning it can be used against them. That is our law. The next argument we raise is that it is law. Supreme Court has said that in the case CC Native Blanco versus the Republic of Liberia, that case was decided in 2009 by the Supreme Court. Delivering the opinion on behalf of the court was former Justice Kabina Mohammed Janeh. The court said, the Supreme Court said, NSA is not a criminal investigation agency. NSA cannot investigate arson. The report that was sent, you will see there, NSA, arson investigation. Extraction of evidence by NSA, the Cyber Security Unit, is December 20, 2024. When the search warrant talks about January 5, 2025. So you did what you did already illegally, and then you went for search and seizure way January. So it is illegal. It can't stand. It is not anything like sentiment or anything like whims and caprices employed. It is nothing like dilatory procedural tactic employed. It is an issue of law. And the evidence on their face show that yes, that is what happened. So NSA is only responsible for clandestine operations, national security intelligence, and functions that they can carry out are only defined in their act creating them. Even the Minister of Justice or the President of Liberia cannot delegate to the NSA an authority that the NSA does not have statutorily to perform. No. In our opinion by the Supreme Court said NSA should not engage in investigations that should be conducted by the Liberian National Police and at that time the National Bureau of Investigation. Now it is dissolved in the Major Crime Unit. So that is the issue before the court. But the state issue of law.
But the state prosecutor, Councillor Rachel Scott, is saying something on the contrary, that there's a communication between the NSA that can assist them.
Authority, Toby, you've been around here for long, more than any other journalist. Authority is not conferred by consent. Authority is conferred by law. Supreme Court said the act that created you is the one that gives you an authority to perform a function. If that act did not expressly state that you can do this, and if you do anything outside of the express authority of the act, your actions are ultra virus.
So what in case the court deny your application, what would be your next move?
Of course, you know what we'll do again, we'll go to Supreme Court. And that's an issue of law. The law has remedies. But I don't want to preempt the judge. as an experienced judge, we lay him with what we said. I am just telling you what we said today before the court, and we leave it on his lap to use the law, because he's the law judge, and apply the law to the applications that we made.
Finally, counsel, if you have a strong defense, why don't you go through the case and then flush the state doing the full trial?
This is what the law says. Toby, I will not be angry to answer you. I will be happy to answer you.